Hello, good afternoon, everyone. Thank you for joining us today and welcome to our 2025 Tribal Healing and Wellness Court webinar series. Today, we're going to talk about strengthening your Tribal Healing and Wellness Court through legal screenings. My name is Jacob Metoxen. I am a legal specialist for the Tribal Law and Policy Institute. I am Oneida from Wisconsin. I'm previous tribal prosecutor, tribal judge, and federal prosecutor. Work closely with our BJA 10 team to help technical assistance for our adult healing and wellness courts. That's not the only thing TLPI does, though. We've got a plethora of groups who help with various legal issues across Indian country. So if you would like to learn more, you can go to wellnesscourts.org. Here, the link on the slide that you see. Or if you have any questions, specifics about this topic or other topics, feel free to email us at wellness@tlpi.org. You can also hit us up in the chat if you have questions during the webinar. Just want to reference that we'll be talking about strengthening your tribal healing and wellness courts through legal screenings today. A lot of this is actually encompassed in our 10 key components, which are located at wellnesscourt.org. So if you have an opportunity, go check those out. And we are also updating those. We're in the process of updating those. The last version is 2014, still relevant, but we're hoping to capture more modern practices and tell stories of recent healing and wellness courts, Chickasaw Nation being one of them in our update. So be on the lookout for that. All right, so I'm just going to start with some general overview of legal screenings in tribal healing and wellness courts from what we've observed as TLPI doing site visits and working with healing and wellness courts across the country. And then we're going to get into a conversation with our guests. I'm very excited to have the Chickasaw Nation represented here via the prosecutor's office, Emilee Hoff, as well as the public defender, Aaron Duck. They will talk about their program and their involvement in it, legal screenings that happen on the ground there in the Chickasaw Nation in Ada, Oklahoma. So we'll get to them in about 5 to 10 minutes. We'll do an introduction, but just to get us started, to get the brain flowing and the conversation going, just want to touch on some high level bullet points regarding legal screenings. And this information is for the most part available in the 10 key components if you check them out, as well as the best practice standards that All Rise has. And so when we think about legal screenings in tribal healing and wellness courts, we're talking about objectivity. And that's important because, when you have objective criteria for who is allowed into your program or who you're accepting into your program, it creates a basis and a standard for participation in your healing and wellness court. And so objectivity means, things like um, jurisdiction, where they're from, criminal history, what sort of offenses they have previously, what the assessment says about the potential candidates. And so avoiding the objective, avoiding, personal um, preferences or looking at somebody and saying, hey, I know their family, I don't get along with their family, I don't think they're going to be a right fit for this program. Avoiding those sorts of objective bias is obviously going to be one of the top priorities when it comes to legal screenings. And I think personally, my opinion is that the legal screening process is catered in a way that helps avoid that sort of objectivity because a lot of the criteria can be found in statutory language. And so that brings us to our third bullet point, which is the federal and the state statutes. So I know if you are a federal grantee, there is a violent offender prohibition. So if you look at that language, it is 34 USC 10613, and that gives you the definition for adult and juvenile violent offender prohibitions who would be excluded based on criminal history as well as the offense that they've been charged with. State is a little different. I know one example is Wisconsin, so that would be statute 165.95. Almost mirrors the federal statute, that 34 USC language, except there's kind of I guess a big caveat in the Wisconsin statute, and this is just one example. Obviously, if you're located in a different state, the language may be different. But the Wisconsin statute doesn't have the felony requirement that the federal statute does. And so I interpret that as meaning that if someone is charged with a misdemeanor that meets certain elements of an offense, they could potentially be prohibited from participating in your healing and wellness court. So I think the big takeaway from that is if you have an opportunity to get your prosecutor, public defender, general counsel, outside counsel involved in these sorts of determinations, then that's always advisable because to be honest, I was looking side by side at those statutes and I didn't necessarily immediately identify that difference. After reading it a couple of times, I did. And so being law trained, I think it's advisable to have, your attorneys involved in that sort of statutory interpretation. And when it comes to tribal statutes, if anyone has any examples of a tribal code setting out what the criteria is for legal screenings, feel free to put it in the chat. I personally haven't seen any. I have seen statutes in tribal codes that um, or sections of tribal codes that basically say, there's going to be a policies and procedures that are developed and should be reviewed annually. And then within those policies and procedures, there will be the eligibility and exclusion criteria. So that language strengthens, your policies and your procedures or your operational manuals and kind of gives credence to that criteria. So that's another thing to take into consideration. And, I think that reference to the general document, the living document, provides some flexibility for, determining whether or not certain eligibility or exclusion criteria works better as your program develops, as you start to learn more, as you get more participants through the door. Um, Another big topic, I guess, when we're referring to jurisdictions and, the three sovereigns is referrals. I live in Norman, Oklahoma, which is not a PL 280 state, but I was raised in Green Bay, Wisconsin, which is a PL 280 state. So if you're in a PL 280 state, I'm sure you're familiar that the state has criminal jurisdiction for the most part. There are some exceptions within the reservation in a PL 280 state, and even if you're not in a PL 280 state, um, you know you can get referrals. There are a lot of our healing and wellness courts that are getting referrals from the county or the parish. If you're in Louisiana, the counties are referred to as parishes. So that relationship between the tribal healing and wellness court and the local DA or ADA is very important. At the same time, though, that level of communication should be heightened because if you do have statutory requirements, if you have a state or federal grant that prohibits certain individuals with criminal histories, then communicating that to the ADA or whoever's making the referral is very important and having that transparency because then you avoid a situation where you get a referral from somebody and maybe the person doing the referring doesn't know about the prohibitions. And then you go down the line, resources are being used in the form of assessments and that sort of information could have been very valuable to make the determination up front, like, hey, unfortunately, the person has a criminal history that prohibits them from participating in the program. And we haven't really seen that issue a lot, just something to keep an eye on for the most part. Thankfully, when we do see referrals between state jurisdictions or counties and the tribes, there's usually someone from the county on the Healing and Wellness Court team. It's a really wonderful sign in terms of collaboration and making sure those lines are open and consistent. And it's been really wonderful to see, especially for the treatment courts or the Healing and Wellness courts in Wisconsin. In terms of jurisdiction, I think this segues very well into our guests from the Chickasaw Nation. For those of you who are familiar with kind of the legal landscape, recently it's been about 5 years. I keep saying recently because it does still seem relatively recent, but eventually, we're going to be 10 to 15 years down the line. Regardless, there was a huge decision in Oklahoma that affected Oklahoma, the McGirt decision. I'm sure some of you have heard that Supreme Court one, and it reaffirmed the boundaries, as Judge Morton from the Chickasaw Nation likes to say, which I like that term. Reaffirmed the boundaries of the tribes in Oklahoma and had a significant impact on the healing and wellness courts here because it expanded the potential pool of participants in the healing and wellness court. And I think we'll hear shortly from Emilee and Aaron about, having that good problem of a waiting list to get into a program because of the vastness of the reservation and the ability to provide these services beyond just one county or two counties. If you live in a reservation that has 17 counties in it, potentially looking at expansion. And so those sorts of considerations are something that always happen, with these legal screening processes. And with the correct policies or statutes in place, you can really prevent, resources being used in a way where, you have to go back and then reuse resources, or, you potentially give candidates hope to be in the program when in fact they're ineligible. And just briefly, the jurisdictional aspect is also important because if you have objective criteria, there could be a criteria that says someone has to live within the reservation boundaries, someone has to live within specific counties, and that is important for where somebody gets charged for an offense or has a case in front of, a county or a district court judge. And so those jurisdictional aspects can be complex at times, but luckily we have people in the field like Emilee and Aaron who can help navigate through any issues that arise. And so we have Aaron and Emilee in the same room. I do have two separate slides, but we're just going to stay on this one because the bullet points are the same. But I want to give Emilee and Aaron an opportunity to introduce themselves and talk a little about the Masali Healing and Wellness Court there in Ada, Oklahoma, and then maybe just talk about some current legal issues that you all are dealing with that has to do with legal screenings. And as I mentioned earlier, if you have any questions, please mention them in the chat. We'll also set aside some time if you want to ask them after they're done speaking on Masali. So with that, thank you, Emilee and Aaron, for being here. The floor is all yours.
Thank you, Jacob. We are appreciative to be here today and thankful for y'all asking us to speak today. So I guess I'll go first. My name's Emilee Hoff. I am with the Chickasaw Nation Office of Tribal Justice Administration, which essentially means our prosecutor's office. I started with the Chickasaw Nation about 4 years ago, 4 or 5 years ago. For those who don't know Oklahoma law, as Jacob was saying, McGirt, through the Supreme Court, reaffirmed our boundaries, or started to reaffirm our boundaries. Our specific court case was the state of Oklahoma v. Bossy, and that dropped in March of 2021, and that's kind of when we started going forward with our own court, seeing an uptick in cases filing within our court. And so prior to us having Bossy, we maybe had 40 a year. And now we're hitting 2,500 easily. And so one of the big things that our governor of the Chickasaw Nation is pushing is rehabilitation within our boundaries. Right now we cover 13 counties for the Chickasaw Nation. And so with that, we started our Tribal Healing to Wellness Court. We started Tribal Healing to Wellness Court back in, I think our discussions with TLPI started in maybe 2022, the summer. We took almost a full year to really implement those and try to visualize how this was going to work within our current system. And we hit the ground running I believe our first referral was back in May of 2023. We got our first couple of referrals at that time. And so at this point in time, in regards to how people get referred, what different criteria we set within our program, we of course follow the BGA grant recommendation, the 10 components when seeking those referrals, but so we exclude violent offenders. But on top of that, as of right now, we are limited to only a county within our jurisdiction, to accept participants from. Our court system and our tribe is primarily set up in Pontotoc County, which is where we currently are, Ada, Oklahoma. And so that is primarily the pool that we pull from. And so and I'm not saying that we don't go outside of that, but there are exceptions or circumstances that must come about before individuals who may not live in Pontotoc County at the time get admitted into our program. On top of additional criteria we look at, we exclude sex offenders in our program, any domestic violence cases within our program. That was specially set by our team due to the fact that we have the capability to prosecute under the Violence Against Women Act. And we do prosecute at times non-Native individuals who commit crimes against First American citizens. And so we as a team decided to implement that exclusionary period or exclusionary criteria. So, anything else? Can't think of anything.
Thank you, Emily. Appreciate that insight. I do have some follow-up questions, but I think we'll shift over to Mr. Duck, the public defender for the Chickasaw Nation. Got an opportunity to meet him during a recent site visit. He's a former judge, and his story is pretty amazing. And I think the nation is grateful to have him in that role, which is relatively recent, correct, Mr. Duck?
Yeah, I'm currently serving as chief public defender. That was an office that basically they started in February of this year, and I agreed to take on that role. I graduated law school back in December of '98, and I immediately started working with Chickasaw Nation, working with them to reestablish their jurisdiction, their tribal court jurisdiction from the CFR courts. I was in private practice with my dad, who was a tribal legislator, and I had an uncle that was a judge, state court judge, who was also a tribal legislator. So I worked with them basically to reestablish that jurisdiction. And Chickasaw Nation opened its courts back up on January the 2nd of 2004. And I was made district judge at that time. So I served like 7 years as district judge for the Chickasaw Nation from 2004 to January 2011. After that, I went to state court as an associate district judge in Murray County, Oklahoma. And I ran our drug court in Murray County during that time. And I did that for like 13 years. And then I came back to the Chickasaw Nation, worked a little over a year as a special judge. And then kind of just by me running my mouth saying we could do the public defender's job cheaper than what we were paying private attorneys to do it, ended up as the chief public defender. So you got to be careful what you say. But the tribal court side of the drug court, I'm still relatively new at. Judge Morton did that when I got here, and I didn't really have any say so other than just I would take pleas to put people in it, and then after that he would handle it. What I have seen on the tribal, on especially Chickasaw Nation version of drug court versus state drug court, has extremely impressed me on what they do. Now, granted, they have a little more funding to help with what they do than what we did on the state side, but it's so much more involved, and they get so much better treatment and opportunities under the tribal side of drug court than we did in the state. And on the state side, early on, I wasn't as much of a believer in drug court as I was toward the end, and I have to admit that. But it didn't take me long, maybe 3 or 4 years into being a judge, to realize that jail wasn't the answer for everyone, and jail does not take care of drug addiction. And so I became a believer in drug court, and my whole philosophy on referrals and letting people into drug court changed over the years, because for the first 8 years I was on state court side. Most drug charges other than marijuana were felonies in Oklahoma, so you actually had a hammer over people's head. And you tell them you can go to drug court, you won't go to prison. If you don't want to go to drug court, you can go to prison. Well, That sounded like a good idea at first, and it worked okay for some, but you also had people in there that didn't really want to be there. They were just basically trying to get out of jail. And sometimes it worked for people when they went in under that premise, and sometimes it didn't. And then Oklahoma changed the laws and made them all misdemeanors. So we took that hammer over our head, and I couldn't tell them, well, you're looking at 3 years in jail versus 18 months of drug court. I had to tell them you're, a year in jail versus 18 months of drug court. And then I had to they figured out that that wasn't the case either. When you have a jail in your county that holds 32 people, you can't put everyone in jail over that. So by the end of my term in state court, I literally, when we were talking to people about going to drug court, it's like, so here's the option. If you could choose between 30, 60 days in jail or the possibility of even going home versus going into drug court and getting help for your problem, which one would you choose? And that was just the honest, that we eventually got to the point where we just had to be honest with people, because that was the truth. That was what it amounted to. We couldn't put everyone in jail, and even if we did, we couldn't keep them because we didn't have room. So, but to be honest with you, my numbers didn't go down when we started doing that, and my success rate went up because we had people there that actually wanted the help. And we had success stories from that, like, it seemed like we had a lot more success stories than failures when we started doing that. I mean, I was in a restaurant in my hometown 2 weeks ago. Lady came up that I knew well, went to high school with her. She gave me a hug and told me her son's still doing well. Her son went through drug court, and he was looking at some pretty substantial jail time because he had some other felonies to go along with just simple possessions that would cause him to go to prison. And I pushed him to go into drug court. He didn't really want to go, but I pushed him there, and he ended up doing really well. And then he actually ended up dating and marrying another girl that was in drug court. And I know that's kind of frowned upon, but they helped each other through that. And they have 3 kids today. They both have really good jobs, and they've been clean for about 6 or 7 years. And you wouldn't even know it by looking at their family. They look like a classic American family. And but every time I see both their parents, I get hugs, and so it was the kind of stuff like that that made me fall in love with drug court. One of my favorite things as a judge to do was drug court. And because you could kind of develop a personal role with them. Now, the good thing is when I was in Murray County, it's a small county. I always joked, and it's probably true though, between me and my wife, we were probably related to about 10% of the county. And I know 90% of them. So I knew their families, I knew their backgrounds, and you talk about the objective versus subjective um, referrals or criteria for referrals. I'm the first to admit I was terrible at predicting who would do well and who would not. There were people that I knew their families, I knew their background. Like, there's no way this person's going to make it through. There's no way, and they would do great. And then there was people that I thought would do great that didn't. And it all fell down on their own personal willingness and readiness for that program, how willing they were to get help at the time. And that is the one thing I figured out in my experience, is that we can put all these criteria that we go through, we can do all these assessments and all that stuff, but you really don't know whether they're going to be good at the program or not, because it all depends on their heart at the time. If they are tired of that drug lifestyle, they're tired of what they've been through, and they truly want help, they're going to do well no matter what their background is, no matter what their assessment says. But if they're not tired of that, and they're still enjoying the rush they get out of partying with their friends and using the drugs, and they're not willing to leave that lifestyle behind, they're not going to do well. And no one knows that but them and God. No, I mean, and that's just the simple fact of the matter. And I think that's why I was so bad at making those determinations ahead of time. So I'm never comfortable with my own judgment on the referral roles. But typically what I still tell them now is, you need to tell me right now. If you had your choice of going home or going to drug court, what would you do? And if you had your choice of getting help and ending this cycle that you've been in for the last however many years, or do you want to go back into it? And that to me has always been if they can honestly answer that question, that has been the biggest determination of whether or not they're going to succeed.
Thank you. I still want to call you Judge Duck, but I know you've transitioned to a different role. But I think your experience speaks volumes in hearing your story, Mr. Duck, and you hit the nail on the head talking about kind of, running into people and looking at who's here for our webinar today. We've got people from Oklahoma, South Dakota, Wisconsin, Maine, Alaska, Washington, the Blackfeet Nation, and I'm sure a lot of our participants here have similar stories, seeing people. And so, Emilee, can you talk a little about coming to, a consensus regarding what that criteria looks like from the beginning? How often you evaluate that criteria. Aaron is talking about his perception of a lot of things changing over time as he got more experience in treatment court. Is that something you guys consider as a team, having, some experience under your belt since 2021?
Yeah. So, yeah, it's always on the forefront of our mind. I think, our Judge Morton, is a big proponent of we can always do better. He always wants to be the best in everything that he does. He'll tell you that himself. And there's always learning that we can do within our own system. And so we are constantly looking to how to better our criteria. And one way that we're doing that currently, we're looking to expand the target population in which our Masali Healing to Wellness Court essentially targets. We have another court system located in Carter County, which is the southern part of our jurisdiction. It's also one of the largest cities within our jurisdiction, and we have a huge target population that is in need of help in that community. And so our hopes and future dreams in the next couple of years is to expand that or this program to that community. From my understanding, we are in the works. We currently have a court system set up there. We have personnel down there. We need to get the rest there to be able to help those individuals. And when I say that our current criteria is limited to a certain county, I can say that there are a handful of participants that have themselves wanted to improve. They have voluntarily moved into our current county where the Masali Healing to Wellness Court is up and running, to be able to receive those services, go through the program, and essentially better themselves in their lives. And I think Judge Duck, and I'm still going to call him Judge Duck. I will never call him by his first name, but Judge Duck mentioned when he came into our system, he really saw the benefit that some of these participants were receiving based off of the services provided. And I have learned, coming from the state of Oklahoma, where I participated some in a Oklahoma state drug court system through Oklahoma County, that those services are just not provided. One of our goals here at the Chickasaw Nation is to help these participants find jobs, to help these participants gain their driver's license and gain housing. We work very well with our current ICW workers if there are custody matters going on. One of our first participants, she came into this program with her substance use problem. She had no driver's license, she had no job, she had no housing, and she didn't have custody of her kids. By the time she graduated our program 18 months later, she had all of those. And we see her kids and her from time to time, and she's doing amazing in the community. And so just being able to assist these participants with that type of lifestyle, because I think we can all agree that the biggest struggle or the only struggle isn't just drug choice. I think if somebody has a stable job and stable living environment, that is going to help them want to focus on their treatment, and bettering themselves. So
Yeah, it impresses me because most of the people that go through this program have never had anyone in their lives actually help them and encourage them to do something. They've basically they've grown up with nothing but negativity and no clear example on how to act as a functioning adult. And I was fortunate enough in state court, my drug court coordinator cared about the people that was in there. He legit made friends with them, he developed relations with them, and he cared about their well-being. The drug court coordinator we have now in tribal court goes out of her way to try to help people. She fights for them more than probably I would as a public defender. And in fact, she called me last night. We had one kind of go AWOL on us a little bit. She texted me last night, to give me heads up. We're looking for her. We're trying to get her back in and make sure she's okay. Wasn't that she was in trouble. She wasn't mad at her. They want to make sure she was okay, which kind of, it impressed me to get that text at 10:30 at night, to be honest with you. And it's amazing though, when you just, when people get that, when people, when you tell them, say, hey, this is what you got to do to get a driver's license, and we're going to help you do that. This is what you got to do to get a house. This is what you got to do to get a job. They've never had anybody in their life tell them that. All they've been told is they can't do it. You can't do it. Just live with it. And once they get that leg up and they can start kind of doing that things for themselves, and then that keeps them. I think that's what the major thing that keeps them from recidivating or going back into that life later. Yeah, relapsing. Yeah, going back into that life later. And and I cuss our outpatient intensive uh, counseling that we have here, because just by the sheer fact that we're limited on the amount of people we can get in it. It is the best possible thing we can do. It's better than anything we had in state court, because we didn't have the resources to do that. But that sets people up to succeed. Even those people that probably aren't ready for that, by the time they get through that, they're set up to succeed way better than they were than I was in state court. My only problem with that is we're limited to the amount of people that we can get in there. If it was unlimited and we could get as many people as we could, I would love it. But I'm really impressed with the tribal end of it. I'm not going to lie. And I wish that the state end had the resources and services available to them to do that. And if we did, I think we could take care of a lot of problems. I would like to see us expand more into, or I would like to see the tribe expand more into our mental health courts. We were working at that at one point. We're kind of still trying to work on that, but I think that's a huge aspect that we need to take in, and we are doing a better job of that. Again, the tribes do a better job of that in their drug court than the state did, and dealing with the mental health issues. And but that is an area that is hard to address, no matter whether you're tribal or state, because there's not enough help out there. There's not enough facilities and treatment providers to cover what we need.
Judge Duck, just to follow up on that, talking about resources being a commodity, and when you have them for a healing and wellness court model, it just being very valuable for the outcomes of participants. I look at the screening process, specifically the legal screening process, as having the capability to save resources when you kind of make a determination or see patterns or have data and say, well, we've got individuals, and we're seeing a pattern where if they have so and so offense, they don't do as well as other individuals who maybe don't have the same criminal history. I guess it's a two-part question. Since the program is constantly expanding, you guys are gathering information. How much credence do you give data as you're going along? And how often are you guys having that conversation to say, because that's a big topic,
Well,
especially drug trafficking, whether or not you will allow drug traffickers into your program. I know we hear a lot of communities who ask that question. They're not prohibited in the federal statute, but I know it can be a point of contention amongst some teams.
well, every person's different, and every person's criminal. I mean, just because two people are charged with the same crime, doesn't mean they were the same culpability in the same act. And I personally have never been a fan of disqualifying somebody just because what they had on paper. And I had an older gentleman. He was in his 60s or 70s. He actually graduated a month after I left the state court, and he was one that I said, "There's no way he could make it through this because of his criminal history." And he had several. I wouldn't say trafficking charges, but several of possessions with intent and distribution charges in the past. But he got to the point in his life where he was done with that lifestyle. And he did extremely well through the drug court program and graduated. And last I heard, he's not been in trouble since. And he had a son that he basically ended up getting into drug court not long after him, and was able to mentor him to do the same thing. And so I understand that you have to do that to some extent because resources are limited, and you have to save bed space for those that need to really be there. But I've never been a big fan of any just hardline references saying, no, this person can't come in because of what they had in the past. You got to, it's more important to figure out, especially if it's something went on 15 or 20 years ago. I mean, so you got to look to me, I want to look on how long ago was it? What were the true facts of what happened? What's he done since then? And where is his heart right now? What's his goals and reasoning for getting himself better and getting away from this lifestyle? Because many times, most of those people who've been in trouble for distribution and stuff like that, they're just trying to support their own habits. And what you see a lot of times is when you send them to prison, when they get out, they have to do that to pay back the drug debt they incurred while they were in jail. Because we all know drugs are just as easy to get in jail as they are on the streets. And the problem is when you get them in jail, you have two choices when you get out. You can steal or deal. But you got to pay back that debt. Nothing's free. So if you give them the drug court option, then it at least gives them a chance to get away from that and gives them a chance to better themselves.
Emily, from a prosecution standpoint, what are your thoughts and kind of criteria? And you mentioned earlier in the beginning about having additional exclusions, not just kind of what the federal grant requirements are. And Judge Duck's perspective is, honestly sounds like a really great mentality, not kind of having an across the board mentality when deciding who's going to be a good candidate because you never know. But the reality is, there are certain requirements that need to happen in terms of criteria. And so when you were part of the program from the beginning, how did those conversations go, in making those determinations? Like, we're not just going to prohibit violent offenders, but we also are going to limit it to individuals who don't have these sorts of histories either.
Yeah. They weren't fun, I'll be honest. At the time we had another defense counsel present, and I'm sure everyone else in the room was worried about what they got themselves into. I think now Judge Duck and I, we're pretty good friends, but we're adversary at the end of the day, on some topics, and this is probably going to be one of them. I have not gotten to the mind, and yes, I treat every referral as a case by case basis in admitting or not, because the way our referral system is set up, I am doing those legal screening and making sure someone who is a violent offender or doesn't meet our eligibility criteria is stopped there before going on to our treatment team and our specialty services team. But as far as past, I think it's almost two parts. I would say if they had a crime, especially, I know drug trafficking and intent to distribute are a huge conversation that a lot of not only tribes but drug courts have a question on, because there isn't a limitation unless it's specifically put within your own code or law. I'm going to obviously have a different outlook on it if they are currently charged with, but I think there's more leniency, and I don't think our team takes it into consideration as much if they have previously been convicted of. But I will say there have been arguments within our own staffing on individuals who have those types of charges submitting themselves to are being referred to our Masali Healing to Wellness Court. Those conversations are had, and most of the time, I'll be honest, our team can't agree. And the one thing I love about our team is if there's not an agreement, we go to the judge, and it's ultimately the judge's decision on who gets into the program and who doesn't. I can count on my hand at least a handful of times that scenario has occurred, and it's not necessarily that it was with drug traffickers or people charged with possession with intent, but other individuals that we may have prior history with and prior understanding of what's going on in their cases. That my role as a prosecutor is to protect the integrity of the program.
And I will say this, I respect Emilee's role because that is a tough decision whether to let someone in that's got a history of distribution because, and that was one thing I always told my drug court is I treat this, my stepdad that raised me, he was a football coach and a wrestling coach. So I grew up with that team mentality. And you're part of a team when you come to the drug court. And if you come in and you're a cancer, I'm going to cut you out because I'm not going to let you bring the rest of the team down. And if you're letting an active dealer into that setting, it's going to bring the whole team down. So you can't run that risk. So, it's easy for me to sit here and say, oh, well, we need to do all this and this and this. But ultimately, when you make the wrong decision, let the wrong person in there, it has lasting effects on other members of that are there. So it's just a tough decision because, like I said, you don't want to. I am extremely glad that there are people I let in against my best judgment because those are some of the ones that did the best and had the best outcome in their lives and their families. But there were some we let in that brought other people down that I regret. So you just got to be willing to take the good with the bad and deal with it as it comes up. And I think that those ones that are close are the ones you really got to watch. And you just can't cut them a lot of slack because you can't give them the ability to bring other members down. But it's hard to draw a hard line for me based on my experience to have a hard line rule that this person can't come in. But you really got to be careful and you really got to pay attention to what's going on.
Understood. And of course, you've got the quote unquote adversarial roles. The public defender's priority is the best interest of his client, and the prosecutors is the best interest of the nation and the victims. And so I always shout you guys out and the team's ability to, maintain professionalism, even though there's always going to be those sorts of issues that could potentially be divisive and unfortunately takes down other teams. One question I have as a follow-up, Emilee, is so when you think about doing and this is my last question, and then we'll open it up to Q&A to our participants here. But just one more question I think would be helpful. As a prosecutor, when you're doing the referrals or the screenings and you're looking for criminal history, the reality is sometimes it can be difficult to get a full criminal history, right? Even on the federal level, it can be hard for federal probation officers to get information from a jurisdiction in another state, and information about a particular offense, the outcome of a case. What's your advice for tribes or healing wellness courts who maybe don't have access to that sort of information or are looking to get access to figure out like they don't want to be in a position where they let somebody in because their background check or their criminal history search didn't show a felony or prohibiting offense that the person actually had? How do you handle situations like that?
Yeah, and so we've actually run into this once before, once thus far. Thank the Lord, I'm gonna knock on wood, but we in the prosecutor's office utilize triple I's. So we utilize NCIC to run all of our criminal history background checks. So, and that's maintained, I believe, by the federal government, and is a tool used by all states, the federal government, in understanding, or I guess reporting, the criminal history. Now, sometimes what we run into problems, especially within the state of Oklahoma, is we have an online system for the state of Oklahoma, that all of our county courts, state courts, and some tribal courts like the nation utilize, which is ODCR, or OSCN. However, there are some tribal courts that don't within the state of Oklahoma. And so trying to find that balance is sometimes very difficult. And there are going to be times where you see things, especially on your NCIC hits, that you have questions about the disposition of, and usually myself, my legal assistant are calling and checking to make sure what the disposition of that case may be, if there's a question as to whether it's a violent offender or not, or a conviction of domestic violence or not. And so there are those questions at times. Luckily, we haven't had major issues because it's as easy as calling that jurisdiction and figuring out the what happened with the case. I will say, because I work really well with defense counsel, sometimes I'm asking defense counsel, hey, there's an alert. What's going on with this? Can you ask your client? Like, of course, that's going to be my last case scenario. But if I cannot figure out, I'm going to have a conversation with defense counsel over here, and ask, what's going on? Was this individual convicted of this or not? And I always explain it to defense counsel as, in these violent offender situations, that's affecting our grant at the end of the day. I don't want something to slip by us and pull the funding that we have available to help multiple participants, not just this one. So that's how I handle it, at least for now.
We wouldn't have to have it either, so.
Right.
Great. And thank you for your guys's answers to questions, and again for being here. We're going to open it up now for our participants to ask any questions that they may have. I know Angie put in the chat. Feel free to use the chat if you have any questions, or I think our participants can unmute themselves, correct?
They can raise their hand and I can unmute them.
Okay, thank you, Janice. Give it a minute or two to see, otherwise I do have additional questions. Okay, we'll go ahead. In the meantime, I have another follow-up question regarding the jurisdictional aspect that we talked about earlier. I know we touched on it briefly. It's complex. Not only is there the McGirt decision, but then there's kind of like branches from that McGirt decision within the state court in Oklahoma, the Supreme Court. Emilee and I had an opportunity to discuss this matter prior to our conversation today. Emilee, can you talk a little about, I think you mentioned it as O'Brien case, and kind of the reality if someone isn't in the legal field or isn't an attorney and has a general counsel office, what sort of things do you have to look out for on a day-to-day basis as an attorney in the Healing and Wellness Court when it comes to jurisdiction?
Well, so in regards to O'Brien, that is a Oklahoma Court of Criminal Appeals decision, and it essentially doesn't limit our jurisdiction, but it gives back some of our jurisdiction, or our, I like to say, sovereignty to the state of Oklahoma. In that decision, they essentially said any First Americans that are committing a crime on the jurisdiction of another. So if you're Creek and you come onto the Chickasaw Nation and commit a crime, that can be prosecuted in both the state of Oklahoma and the Chickasaw Nation. And then you also have federal jurisdiction depending on the offense. But what we have seen within our own office and challenges with that is a lot of law enforcement is choosing which jurisdiction to send it to. So there are times where First Americans are solely being sent to the state of Oklahoma to be prosecuted and we're not getting that opportunity to serve our community, to serve justice within our community, and at times not serve justice on First American victims. So there's obviously concerns there, as well as limitations or decrease in the types of cases or amount of cases that we're receiving to prosecute through our courts. I will say our office has done, I feel like, a great job with communicating with our local DAs in the uncertainty of this decision, and we haven't felt as many effects as maybe some other tribes have within the state of Oklahoma regarding that decision. And so I think there's only maybe a couple of counties that are really moving forward under O'Brien and prosecuting First Americans under the state court. But because of our relationships that have been built with other counties, we're not seeing that become an issue.
That case goes directly against McGirt, because McGirt was a Creek that committed a crime on Cherokee in the Cherokee Reservation, and the McGirt held, or the Supreme Court held, that Cherokee Nation had exclusive jurisdiction over the state. So I can't see that decision lasting long if it goes up to the Supreme Court, if they're going to follow their own precedents. But it's what we're dealing with now.
Yeah, and I mean that is a reality. We're always oh, sorry, Emilee, did you have a follow-up?
No, I will just say I have the Q&A box, and I see a question from, and I may butcher, is it Janine Butchmeyer? And that she says, if a grant-funded wellness court were to accidentally serve a participant that had a violent offense unknowingly, but release said participants once they found out, would they still be possible to lose funding? And so I will say, when I started, Janae, I'm so sorry, Janae, thank you for telling me that in the chat. I will say, when I first started this role and heading our tribal healing to wellness court, I got in contact with our BGA grant representative. I have been in close communications with her in regards to this. I will say, under the grant funding or proposition of not allowing violent offenders, there's almost like a little exception. So there's an exception if you use your own funding, and then two, you can ask for, what do they call it, like a justification.
Yeah.
Is what I'm thinking of. And so I would talk with your BGA grant representative in regards to that, because I don't have the answer, I'll be honest. But in doing so, at least making them aware, maybe ask these hypotheticals beforehand, because they may allow justifications after the fact. I just don't know. Or if you have your own funding supporting your program, there's a way that you can solely use that funding, but it's very specific on how you have to report that.
There's also an out for those close calls too, and I may butcher this trying to recall exactly how it's done, because it's been about 2 months since I looked at it. But under the rules themselves, when you're talking about who's a violent offender, almost ones that could potentially be or may not be based on the definition, there's a way where you're I believe it's the tribal prosecutor will do an opinion that under local customs and local laws that it doesn't meet the definition as a violent offender under the federal law, then that will cover you. And even if they come back and determine that person is a violent offender, didn't qualify, as long as you have that opinion letter on those close calls, you should be covered and not have to worry about losing your grant funding. Is that correct?
I believe so, but
We
it's been
talked about that. It's been a couple
minute.
months since we talked about it. Yeah. But the language on that's pretty clear that you can kind of cover yourself if you follow that procedure.
Thank you for those answers. And Janae, as Angie mentioned, will follow up as well. We'll solidify some information for you, and we'll follow up after the webinar. And it looks like Janae has a follow-up that we haven't had it happen yet that we know of, though I have been a bit worried as we work primarily with youth and don't have a great way of finding criminal background information for minors. Yeah, that's a great point. I think we've seen other communities who, depending on the location, what the probation or police department will do is will reach out to neighboring jurisdictions just to kind of see like if there's an indication that someone's lived in a nearby reservation or has family, do your own due diligence that way in the event that the information isn't available on a national network. But appreciate your question, Janae, and we'll definitely follow up after this. It looks like we got another one. April, January, is asking, does your tribe utilize tribal access program to conduct background checks, fingerprinting? TAP gives you the ability to have access to NCIC as well. It is a new program for our tribe.
Yes, April, that's the exact program that we use through NCIC to conduct our background checks.
Any thoughts on the usability of that program? Run into any issues, or is it pretty clean?
No, I love it. One thing that we're working on with our police department is actually being able to put dispositions in. That's taken us some time. So with that, we're wanting to continue to use it and utilize it, but there's of course a learning process in getting that fully operational.
Okay. Thank you, Emilee. Appreciate it. I just have, we're on the hour. I don't know if we have any additional questions. It doesn't look like it, but one thing go
Jacob,
ahead, Angie, sorry.
sorry
Yeah.
to interrupt. There was like a follow-up, which I think was in regard to the tribal access program. If there's having to pay a membership or some kind of cost to use that.
And I believe that's from Janae. We implemented that 4 years ago. I can't recall. I think we used some type of grant funding, or maybe it was grant funded. But I'm sorry. My mind has been all over the place these last 4 years trying to get everything implemented within our court. But I can look into it, Janae, also and let Jacob know.
Thank you, Emilee. She says she's going to look into it as well. So if anyone has any answers, just let us know. We'll incorporate that into our next discussion. And April says you have to apply to the TAP. All right, just one more follow-up question. I guess generally speaking, as I mentioned, we've got participants, people on here from some PL 280 states where obviously state and tribal collaboration is very important. And Judge Duck, you spoke on your experience as a state court treatment judge, which I think is unique. I haven't heard of, another healing and wellness court having someone like you on their team in a public defender capacity. Can you talk a little, with the reality of the legal field, the landscape ever changing? Can you talk a little about the importance of having those good relationships and, what the Chickasaw Nation does to maintain those, considering, a lot of our communities are impacted by similar substances, regardless of jurisdiction?
You mean good relationships between the state and tribes?
Yes, yes. I'm having seen both sides as a state judge and now as a tribal public defender.
It's very important, and I think we're fortunate here. See, I mean, Murray County is right in the heart of the Chickasaw Nation, and the judicial district that I was in covered almost every county in the Chickasaw Nation. So I'm still to this day, I'm in a group message with all the judges in our judicial district. And when, it seemed like there was more conflict, when there was conflict on jurisdictional issues, right as McGirt came around, there was a lot of conflict. And just having the ability to have communications with judges and DAs in the district is huge. It takes care of a lot of problems, and it heads off a lot of potential conflict and a lot of wasted time and money, to be honest with you. I honestly, when McGirt first happened, me and another judge in our district, I was still in the state court at the time, got into an argument because he wanted to dismiss adoptions, divorces, and everything because we lost jurisdiction on everything. And I said, no, we didn't. This only has to do with criminal cases. We're not going to go that far, And then, and I had communications with tribal officials back then on how to do that transition and what we were going to do. And it made things go a whole lot smoother. Things could have blown up and been a real problem had we not done that, and had the tribe not reached out to me. And they did it because they knew I was Chickasaw. They did it because they knew I had worked with I'd helped establish the Chickasaw court jurisdiction to begin with. And but I was able to go talk with other judges in our district, and then set up meetings between tribal officials and them and DAs. And I think that the transition, it helps smooth the transition. I'm not taking responsibility for that. I'm actually putting the praise on the tribe for reaching out and doing that. Because they took initiative to reach out to the state side to get that done. And any problems or concerns were addressed easily and handled easily, and never really came to light. It was handled, via meetings versus through courtrooms and through the media. So I think I mean, I don't know how much y'all were involved in that at that time, but to me, I thought it was, compared to what it could have been, I thought it was an extremely smooth transition. And a lot of that was direct because of the Chickasaw Nation being proactive in reaching out to the state officials to communicate and head off those problems before they got there. Did I answer the question you asked?
Yes, and in the future, Judge Duck, I'll work better on my questioning skills.
No. I mean,
that
sometimes I'm getting old and senile, so sometimes I get confused easy. So I was hoping that that's where you were going with that. But.
Well, if there's any, evidence and there needs to be a hearing regarding your capacity, Judge Duck, we've got this recorded. But Emilee, and just a follow-up question for you. You talked about potential expansion. That's a really good thing because, you have that ability, to select and be selective of potential participants, people completing, turning their lives around, things of that nature. Can you talk some more about expansion, if there's a role that the state can have in that expansion, considering the size of the reservation?
Yeah. Well, I don't know as far as role with the state. I think it would be very dependent, and obviously Judge Duck and I here are going to be very biased against O'Brien, thinking that it's bad law. But should that come into play and be found to be good law, I think there's another conversation to be had with our role with our treatment side in the state of Oklahoma in providing those services to members of First Americans within our boundaries. Prior to McGirt, I know our specialty services team and our treatment team were heavily involved in the state court system in providing those services to First Americans. So they've done it before. I believe we could institute something to do it again. But as far as expansion, of course, our goal is to continue to serve the population of within the Chickasaw Nation and serve hopefully one day all counties within the Chickasaw Nation, because I believe, I can't remember who said it, but maybe it was Jacob, that substance abuse issues don't reside in one location. We suffer it nationwide. And so I think it's important, and as our court systems continue to grow, I think our expansion of these specialty courts will also grow.
And Judge Duck, any thoughts on that potential issue in the future?
Oh yeah, they've heard me complain ever since I got over here that we don't let enough people in, and we don't have enough. We can't cover enough of our area. And I think I made everyone mad at the first meeting I sat on. Is I said, y'all are doing too much. You're doing too much with what because we can't accommodate everyone. And I can understand them taking offense to that because they do a great job, and what they do heals people. And I understand that we're limited in resources and people to carry out the treatment and stuff that were necessary for us to do it. We would need a lot more staff than what we have in order to accommodate our entire nation. But I've been preaching from the beginning. We may just have to do less so we can accommodate more. But that's not a good answer either. That's falling back to where we were in the state, and not the state was bad, but that was our philosophy. We do what we can do to accommodate everyone that comes in. And I don't after when I first got here, I thought that was the way to go. After seeing the way our drug courts ran by Judge Morton, I'm starting to see that I was probably wrong about that. We're probably better off to try to give the best help to those we can, given what we have.
Well, you guys have done such a tremendous job, and it always feels like, um, a privilege to go and observe and see your guys' court in action. If anyone ever has any interest in going to visit, I don't want to speak for the Chickasaw Nation or Masali, but I know you guys are encourage others to kind of have a conversation with you, check out your court operations, and we're always doing our best to put the word out about Masali because you guys have a really good program going and seeing all the progress being made with your graduations and it having a real valuable impact on the community is something that we're proud to be associated with. So thank you again, Emilee and Judge Duck, for participating. I don't think we have any additional questions in our Q&A. So appreciate your time. If you have any closing thoughts, please feel free to share.
Well, thank you.
Yeah.
I appreciate you letting us talk.
Yes, thank you, TLPI. We appreciate it, of course. And anyone who has any interest of learning how we run our program, please feel free to reach out to Jacob, and he knows how to get in contact with me. So our team is always willing to help and give y'all additional information if needed.
Your uncle, thank you guys again. And if you have any additional questions or interested, you can go to home.tlpi.org. We've got some good resources on there. Like I said, we're in the process of updating our 10 key components with some recent resources and some additional information that we've picked up as an institute since the last version in 2014. We can also be reached at wellness.tlpi.org if you're interested in learning more or potentially interested in a site visit. And I think we've got our evaluation slide next. So if you could please fill out an evaluation for our discussion today, that would also be appreciated.
Thank you again.
Thank you guys.